Thank you. Right, let's start with appointment of chair. I'll pass over to Ben.
Yes, we have our chair of licensing here today, so I don't suppose we really need to go through that process. Thank you. Over to you, Chair.
Nobody else wants to do it today? No? Fine. Perfect. So I am Councillor Emily Strodwick and Chair of the subcommittee. I'm just going to go through some fire safety rules. In the interest of safety, if the continuous fire alarm sounds, please evacuate the room and public gallery by the stairwells. Do not attempt to use the lifts and please assemble at Queen Victoria's statue in front of the civic offices. In order to comply with the Guildhall Trust Fire Marshal regulations, please remember to sign out when you leave the building after today's meeting. For those of you who have not attended this committee before, I'll explain the running order. You should all have a running order in front of you. I will go through that once I've finished. Please be aware this is a public meeting, so that members of the press and public are also permitted to record the meeting on the understanding that it neither disrupts the meeting nor records those stating explicitly that they do not wish to be recorded. If you want to speak, you just need to press the microphone and then press it off to kind of stop talking. I'm going to go around and do introductions. If I start with my right.
Councillor Jason Fazackley, Member Subcommittee.
Councillor Ian Kadineron, Member of the Committee. Thank you.
And then I'll start from front.
Good afternoon. My name's Ben Attrell. I'm a solicitor employed by the Council and I'll be advising the subcommittee today.
Good afternoon. Derek Stone. I'm the Principal Licensing Officer.
Good afternoon. My name's Immigration Officer Smythe and I'm representing the Home Office today.
Good afternoon. I'm PC 22121 Buchanan. I'm representing Hampshire Licensing Authority.
Good afternoon. My name is Paul Thornton. I'm a licensing consultant representing the premises licence holders.
And behind, if I could get you to introduce yourself, if that's all right. Oh, they're not speaking at all.
Yeah, Chair. The gentleman to the first two gentlemen here, sorry, are the current managers of the site, and the other gentleman is he is just observing today. So, but I don't. Sorry, I don't intend to call any of them to talk this afternoon. But I can give you their names if you like.
Yes, please.
Mr. Manuel Alonso. Mr. Alex Diaz. Thank you, Chair.
Thank you. And then last but not least.
I'm Alison Harper, Local Democracy Officer. I'll be taking the minutes today.
Thank you. So if you don't have the running order, I'm not sure, you might have already explained to them the running order, but I will just explain. Quickly, declarations of members' interest. Are there any declarations? No? Fine. So how today's going to go is Derek's going to open and outline the application case, and then if any of the subcommittee have any questions, we will ask. If any of you have questions, you are then able to ask. I will then go to the Home Office, and then the police, and then it will be yourself. And then summing up, you will be last, so you'll get the final say as well. So we'll go back around again, and then we'll go into private session to then deliberate. Let's pass over to Derek, if that's possible.
Yes, good afternoon, members. So this is a review hearing in relation to Casa Flamenca 2223, the Boardwalk, Portsmouth. The holder of the premises licence and the DPS is recorded as Mr. Kasru Mia. The application and grounds for the review are attached on Appendix A and have been submitted by the Home Office Immigration Enforcement and relates to the following licensing objective, which is the prevention of crime and disorder. The background is that on the 2nd of November 2024, Home Office immigration officers visited the premises where they encountered, they thought, 2 immigration offenders working at the premises. They noted that the CCTV there was not working at the time, it was inaccessible, and reported it as a breach of the condition attached to the premises licence. In relation to that, members, obviously we were notified that immigration had visited the premises. I actually attended and did a licensing check. And whilst the CCTV was in operation, it worked on a telephone app and the manager then didn't have access to that. And it was just a question of actually linking them into the app so they could view the CCTV. I returned a couple of days later and I can confirm that the CCTV was working and recording correctly. So as a result of the immigration offences, a review application was lodged requesting a revocation of the premises licence, and it was referencing paragraph 1127 of the statutory guidance. So if I can just jump to page 5 of my report, 1127 says there is certain criminal activity that may arise in connection with licensed premises which should be treated particularly seriously. And if you scroll down the list, third from bottom, one of those is from employing a person who is disqualified from that work by reason of their immigration status in the UK. So as a result of receiving the review application, in accordance with the Act and prescribed regulations, we placed a public notice at the premises. The review of the application was advertised in the civic offices and also on the council website, and we notified the responsible authorities as well. In response to that, a further representation was received on behalf of the Chief Officer of Hampshire Constabulary supporting the review application, and you'll be hearing from the immigration officer and the police very shortly. So members, the statutory guidance provides advice in relation to the consideration of a review application. In particular, members should have regard to the following. Paragraph 2.6, the prevention of crime includes the prevention of immigration crime, including the prevention of illegal working in licensed premises. Licensing authorities should work with Home Office immigration enforcement as well as the police in respect of these matters. The Act provides for you a range of powers that you can exercise when determining this review, where you consider them appropriate for the promotion of the licensing objectives. You may decide that the review does not require it to take any further steps appropriate to promote the licensing objectives. In addition, there is nothing to prevent a licensing authority issuing an informal warning to the licence holder or to recommend improvement within a particular period of time. Where the licensing authority considers that action under its statutory powers is appropriate, you can take any of the following steps, and that is to modify the conditions of the premises licence, exclude a licence or activity from the scope of the licence. You can remove the designated premises supervisor, suspend the licence for a period not exceeding 3 months, or you could revoke the licence. At 1128 in the guidance, members, it's envisaged that the licensing authority, the police and the Home Office and other law enforcement agencies which are responsible authorities will use the review procedures effectively to deter such activities and crime. Where reviews arise and the licensing authority determines that the crime prevention objective is being undermined through the premises being used to further crimes, it is expected that revocation of the licence, even in the first instance, should be seriously considered. Members, I don't think I need to add anything further to my report. Obviously, you're going to be hearing from immigration and from the police during the course of the proceedings. Thank you.
Thank you. I just have 2 questions. When you went to do the check for the CCTV, was there anything else that was a concern when you went to check? And also, has this premises been brought to your attention before this matter for any issues?
So in relation to your first question, the only other concern was it wasn't as part of the premises licence. I had a concern in relation to the fire exit at the rear of the premises, and I have to say I engaged with the DPS and within days it was rectified. I was very impressed with how it was rectified so quickly, and we've had no other concerns in relation to the premises as far as I'm aware of.
Thank you. Members, do you have any questions at this time? No? Does anyone have questions for Derek at this moment? No? Perfect. I will pass on to the immigration officer now, please.
Good afternoon, panel. I'd first like to confirm that all committee members have had time to read the submission pack. Thank you. I don't propose to read through the full pack, but I will make a couple of key points that I summarise this case. The ability to work illegally in the United Kingdom is a key driver of illegal migration. It encourages people to break UK's immigration laws and provides a practical means for migrants staying unlawfully in the UK. It encourages people to take risks in trying to enter the UK illegally by putting their lives in the hands of unscrupulous people smugglers and leaves them vulnerable to exploitative employers. Illegal working results in businesses that are not playing by the rules and undercutting legitimate businesses that are. It also negatively impacts on the wages of lawful workers and can be linked to other labour market abuses such as tax evasion, breach of national minimum wage and exploitative working conditions. Employing illegal workers undermines the licensing objectives, specifically the prevention of crime and disorder. Immigration enforcement do not just drive around looking for businesses to target. We are an intelligence-led organisation and there have to be significant concerns for us to action that incoming intelligence. We do not routinely refer to seek a licence review, but we do so in cases where we have heightened concerns. To summarise, on the 2nd of November 2024, South Central ICE team visited Casa Flamenca after intelligence was received that the premises was illegally employing Spanish and Indian workers. Entry to the premises was gained under Section 179 of the Licensing Act 2003. 8 workers were encountered in total, and 2 workers were subsequently found to have no permission to work in the United Kingdom. Full details of the illegal workers can be found in the review application pack submitted. When the manager was interviewed, he stated that the workers were friends of his and he was just helping out rather than them being permanent employees. He stated that he was aware of how to conduct the requisite right-to-work checks and talked through the process with the interviewing officer, who was myself. However, he did state that he was unaware that helping also constituted employment and working at the premises. The Home Office provides a free right-to-work check system on gov.uk. This is a checking service, and it would have quickly and easily shown that neither worker held the appropriate rights to work lawfully in the United Kingdom. As a result of this visit, an enforcement penalty, or a civil penalty, was raised for £40,000, and it was issued on the 7th of February 2025 to MA Tapas Limited. The business objected to this penalty on the 10th of March 2025. However, the civil penalty was maintained at £40,000 on the 1st of April 2025. I would state that at this time, the civil penalty still remains unpaid and has now been referred to a third-party debt collection agency as a result. In addition to the illegal working, officers were able to evidence that the conditions relating to CCTV had been breached. This included the requirement that a member of staff must be on site at all times who is trained in the use of CCTV systems. Also, we have concerns that the illegal workers were not trained to serve alcohol responsibly or to refuse sales. The outcome we seek is that Section 182 of the guidance, as my colleague in licensing has pointed out, at point 11.27, outlines certain criminal activity that may arise in connection with licensed premises, which should be treated particularly seriously. This includes employing a person who is disqualified from that work by reason of their immigration status in the United Kingdom. Point 11.28 states that where a review arises from such activity and the licensing authority determines that the crime prevention objective is being undermined through the premises being used to further crimes, it is expected that revocation of this licence, even in the first instance, should be seriously considered. The employment of illegal workers has been clearly evidenced here. The non-compliance with the civil penalty has also been taken into account when considering action with regard to this licence and bringing it to a review. We have no confidence that imposing licensing conditions, changing the DPS, or suspending the licence would remedy the situation. Therefore, we submit revocation of the licence is to be considered. All of that being said, we recognise that our role is to bring these concerns to your attention as the local licensing authority. This is your area, and it is you that answer to the electorate and represent the interests of the local people. Unless I can answer any specific questions, I don't propose to take any more of your time, and I thank you for your attention and your considerations.
Thank you. At this time, I only have one question, and it's regarding the fine, because on the back page it says Total penalty has been calculated to be 40,000 for one worker, but you've made reference to two. Can I get clarification?
Yes, there were 2 workers that were encountered, but one worker did not meet the threshold for the civil penalty. So that is the reason why there is only one on the civil penalty referral notice and the subsequent civil penalty.
Thank you. Members? Mr Fasackley?
Mr. Fazakli, thank you very much. Next. I've only one, it's only a small point. You mentioned there Indian and Spanish workers. I can't see any reference to any Indian workers. I've got somebody in here who's listed as a subject of the United States and somebody else that's Spanish. Was that an error? Or?
No, not at all. The intelligence was for Indian and Spanish workers, but that doesn't necessarily mean to say we don't encounter anybody of other nationalities when we visit. We did encounter one Spanish worker, but he was the one that was not, that didn't meet the threshold for the civil penalty.
So the one that failed to meet the threshold was Indian?
No,
correct?
Spanish.
Spanish, right, okay, all right.
The only other thing I would add, I know we have to obviously block out the names, but it did get a little bit confusing on who was being referred to. So whether there's a system in place just to, even if there's like an initial, because at one point I thought it was the same person twice. So that's the only little niggle. But yeah, it was slightly, I think the others were a bit similar on that one.
That's okay, thank you. I mean, our CPCT team redact everything before they give it to me, but I shall feed that back and see if we can bring it forward with regard to initials in the future for ease of reference.
Thank you, yes,
You're
but especially
welcome.
when they're all male, it's, yeah, just
Yes.
a little bit, but makes sense.
Not at all, I appreciate that.
Any other questions from members? No? Do you have any questions? I've got no questions, Chair. Yes, go for it then.
Hopefully just a straightforward one. I noticed that you mentioned that the civil penalty was issued to a PK Tapas, was it? MK? MA. Okay. Is that, I'm just wondering what that company is in relation to the premises, given the premises licence holder and the DPS are Mr. Mia, is that correct?
Yes, that's correct. MA Tapas is, there's a registered company address for Casa Flamenca at the Boardwalk, so it's directly connected to the business.
So it's essentially the company is the owner of the business.
We levy the penalty to the company,
Okay.
yes.
Yes, I just wanted to know, was there any reason given to you for not paying the penalty given to them? Was there any reason? Did they give you any reason for not?
Not that I'm aware of, but the procedure is we go in, we write the civil penalty referral notice that gets referred to our civil penalties team. They then have contact with the business, and the business then have their opportunity to explain their side of what happened. Based on the evidence that is provided then and the evidence provided by immigration, the fine is then levied, potentially. They then have the opportunity to object to that, and there is a 28-day appeal period, which they've obviously done, but it was upheld, and I'm not privy to the reason why. But then they are told, yes, the decision's been upheld, and then you have to make payment, and they haven't made payment or made contact with the Home Office, as far as I'm aware, to explain why they can't or won't make the payment. You're welcome.
Thank you. Right, your turn. Thank you.
Good afternoon. I'm not going to repeat through exactly what's been said by the immigration. I'm just going to paraphrase what's been said by my colleague. The Chief Officer of Police has major concerns in relation to this incident, which cast serious doubt on the premises' ability to promote the licence and objectives, notably prevention of crime and disorder. The premises licence holder, DPS and manager, through their actions have broken the law whilst putting people at risk for their own personal and financial gain. This is completely unacceptable. For clarity, the premise licence holder and designated premise supervisor are shown as the same person, Kasura Mahaya. It is clear that to the Chief Officer of Police that this premises has been used for criminal activity, namely the employment of persons who were expressly forbidden from employment from reasons of their immigrated status. The fact that the CCTV system was not operational and when requested could not be provided by the manager could be considered a breach of the premises licence on their Annex 2 conditions. I'm aware that this has now been rectified and been checked by my colleague in the Licensing Committee. As detailed within the review paperwork submitted by immigration officers, the checks that must be conducted by an employer have not been completed. These checks are a requirement for any employer and have not been conducted and have been deliberately ignored. The Chief Officer of Police fully supports the review application made in relation to Casa Flamenca by immigration officers. The Chief Officer of Police has considered what action the committee should take in relation to this review. Given the nature and severity of the actions of the premises licence holder, which have seriously undermined the licence and objectives, the police position is that no measures could be imposed upon the licence which could satisfy us that the premises could promote the licence and objectives. As such, we respectfully request that consideration is given to revocation of the premises licence. Again, this is all under the Section 182 guidance that's already been repeated.
Thank you. Members, any questions? No? Do you have any questions? No? Okay. Perfect. Moving on then. Now your turn.
Thank you, Chair, and good afternoon, members of the committee. My name is Paul Thornton, and I'm a licensing consultant, speaking on behalf of Mr. Meir, who's the current premises licence holder at DPS. I'm also speaking on behalf of Mr. Alonso and Mr. Diaz, who are seated behind me. Mr. Diaz was actually one of the managers at the site on the night of 2nd November 2024, and Mr. Alonso is one of the original investors in the business and helped set it up in 2019. But now, although still an investor, does not have a current role to play in the management of the site. As I said earlier, Chair, they do not intend to address you this afternoon. I can assure you and your committee that my clients are extremely worried for the future of their business and are under no illusions as to the severity of the situation this afternoon. Nothing I say or propose this afternoon can change the circumstances of why we're here. I do intend, however, to submit some mitigation regarding this matter, and in the spirit of natural justice and the fact that they have a business to run, I trust you will view my submissions to you and your committee in that light. A brief history of the site. It's in Port Solent. It's in a beautiful position overlooking the marina. Licensed since 2014, providing 80 covers. It started out life as an Indian restaurant, and then in 2019 it transferred to its current format as a very well appointed, smart, well respected and busy Spanish tapas restaurant. In the summer months it employs full and part-time some 20 people. Outside of these months a dozen employees. During all this time it's been licensed, 11 years total and 6 years under this management. It's only ever come to the notice, official notice and for official visits recorded of the responsible authorities as a result of this immigration visit. Moving on, Chair, I'd like to reference the representations from the two responsible authorities, the Home Office and Hampshire Police. Now, the business owners have been punished by the Home Office's immigration team as outlined by their representative today. Whatever I say to you this afternoon will not and cannot change that punishment, and I do not address you with that in mind. This forum is not the place to discuss legal issues and legal niceties. So if I can turn to their submission, and I'd like to give you some background information about that visit on the 2nd of November 2024, which you will note is 361 days ago. They submit evidence relating to two men. In fact, on appeal by the business, as has already been stated, one of the cases, that of a Spanish national by the name of Francisco Ruano, was dropped. He was not there illegally and the business is not liable for a penalty in his name. So the penalty relates to one person and not two. That one person is an American citizen by the name of Brian Wilk. Mr. Wilk is a cousin of the manager at the site, Alex Diaz, who's sitting behind you in the white shirt. Mr. Wilk was born in the same town in Spain as Mr. Diaz, and they lived closely to each other until Mr. Wilk and his parents, which is Alex's aunt and uncle, emigrated to the USA. Mr. Wilk came to the UK at the end of September 2024 to visit his cousin Alex for a holiday. Indeed, during this time, he was also planning to visit his family, or some of his family, extended family in Spain. He had a return ticket to the US booked for December 2024. Whilst staying in the UK, he stayed with Alex at his flat. They did some sightseeing, some of the usual tourist stuff, and then went out together in the local area. Alex clearly had his job to do at the restaurant, and when he went to work, Brian tagged along and used to sit around the restaurant, as it was put to me, rather than sit in his cousin's flat and consume the best or debatably the worst of British television in the evening. When it got busy, he helped out. More to relieve a bit of boredom, but mostly give himself something to do in the restaurant. This didn't happen every night, and as he's told the immigration officers, and which is accepted, he wasn't paid for this. So on the evening of 2nd of November 2024, which I understand was a Friday evening in the restaurant, a very busy evening, the immigration team, acting on information, came to the restaurant in Port Solent. They were specifically looking for Francisco Ruano, man I previously mentioned. Mr. Ruano was outside the rear of the restaurant talking to a couple of friends who he used to work with. And the Home Office team, as is evidenced by the representatives this afternoon, interviewed him and interviewed other employees. Whilst this was going on, Alex, the manager, was attempting to keep a virtually full restaurant of customers happy. But clearly, the service was interrupted because the immigration team, quite lawfully, were exercising their powers and were interviewing the staff. Brian Wilk, who had initially been sitting in the restaurant, not working, pitched in to help when he saw that customers were waiting without service, and got on with serving people. As the visit by the team was winding down, one of the team overheard Brian's American accent, who until then hadn't been spoken to. He was engaged, and as a result of his answers, was arrested along with Mr. Ruano. Both men were subsequently deported just over a week later from the UK, having spent a week in custody. The ironic thing about this is that Mr. Wilk was due to leave the UK on the 3rd of November to visit Spain for a couple of weeks to see his extended family. That trip obviously never happened. Committee, Mr. Wilk told the immigration team, and this appears to have been accepted by the Home Office reasoning for their final decision, that he wasn't paid or contracted to work in the restaurant. He was over here for a visit, he had a return ticket to go back to the USA, and was simply in the restaurant to pass time while his cousin was managing the place. As I stated earlier, I do not intend in any way, shape or form to argue the definition of working or the circumstances as put forward by the Home Office. But I do suggest to you that these circumstances are unusual and at the lower end of the scale for deliberate flouting of the UK's immigration employment regulations. I would suggest there has been no deliberate attempt to circumvent the immigration law in this matter, and I would respectfully ask that you take these unusual circumstances into consideration when making your final decision today. Moving on to the evidence of the immigration team that they were unable to gain access to the CCTV. The CCTV was working that evening. Mr. Diaz, the manager on the night, was the man asked to provide access to the CCTV. By the time he was asked to access the CCTV, the immigration visit, i.e. the interviews of the staff, had been wound down and they were about to leave, as I understand it, and those are my instructions. He indicated he didn't know how to how to access the CCTV, as he tells me he simply wanted the immigration team to leave, as he could only foresee more delay and disruption to his busy Saturday evening restaurant, losing customers rapidly. In short, he wanted them gone. Now, he accepts that was entirely wrong. And in his frustration, he realises he brought more negative comment about the site as a result of that decision. The representation also makes critical mention of the premises for lack of training records, but does accept that training was provided to staff. It also makes critical mention of a lack of a refusals register, citing good practice to have one. The requirement to document training or keep a refusals register does not form part of the conditions on the premises licence. And whilst I absolutely agree that it is good practice, it's disappointing that the site have been criticised for not having such documents when no evidence has been produced to suggest the absence of either of these documents has had a detrimental effect or been the cause of an untoward incident because of it. Moving on to Hampshire Police, they've made a representation supporting the immigration team's request for the licence to be revoked. Their representation mirrors exactly that of the immigration team, but it doesn't identify any additional issues with this premises other than those submitted by the Home Office team. Members of the committee, as I've just stated, today is 361 days after the immigration visit. And since then, the site has not come to notice of any responsible authority. These review proceedings, instigated some 44 weeks, that's 308 days, after the visit, came as a huge shock to the management, who were under the impression everything had been finalised as a result of the immigration visit. Now, I would like to draw your attention to a number of very positive actions that have taken place with the management and running of the restaurant since 2nd of November 2024. Mr. Diaz has successfully become a personal alcohol licence holder with this authority. One of his staff, a man called Ravi Kurukula, has also passed his personal licence qualifying exam and is currently waiting for the personal licence application to be processed again by this licensing authority. Mr. Diaz, to his credit, has got all the licensing and immigration paperwork for the site into order. This includes right to work checks, training records, a refusals register, DPS authorisations, and particularly as the CCTV has been mentioned, instructions for any member of the staff to access the system on request. In short, the management of the site, having recognised shortcomings nearly a year ago, has grasped the nettle and decided to follow the good practice by organising its documentation paperwork. This in addition to these two members of staff obtaining personal licence qualifications. I would suggest to you that this is a fine example of good management taking steps to rectify a situation. The fact that they haven't come to notice to any of the responsible authorities in the intervening period, and let's face it, a year is a long time to prove themselves or for something to go wrong. I would urge you to take account of this in your deliberations. Committee, quite rightly, you may well be asking, or thinking about asking, why the premises licence holder and DPS, Mr. Meir, is not here, and why he's still in position. Mr. Meir is the leaseholder of the site and was the original DPS and premises licence holder for the Indian restaurant. As he's the leaseholder of the site, and it's not an uncommon story, it's almost an exercise of control of a different premises and different management that's actually in the site, as it were, as it is now. So originally, Indian restaurant, now it's a Spanish restaurant. So even though he's got no part running the site, he has managers in there. He's still the figurehead as the DPS and the premises licence holder. He realises that this is a foolish position, and the best people to run and display responsibility for the safe running of a site are those in day-to-day control. So my solution to this would be that we will transfer the premises licence holder and the DPS is transferred to either to Mr. Diaz, and that the premises licence is transferred to Mr. Alonso or a company with his name on it. So I would argue most strongly that the day-to-day management day-to-day management and staff has shown themselves to be very diligent and committed to identifying and addressing the problems identified. And it is to their credit that steps have been taken to ensure nothing like this can happen again. So, with my proposal in mind, you may well ask why this hasn't happened before today. I'm a late arrival to this, and by that I mean I've only been instructed during the second week of the review consultation period. Whilst my initial thoughts were that a change of premises licence holder and DPS were the absolute minimum, the practicalities of doing this during a review consultation period, in my humble opinion, is likely to cause confusion all round. And by this I mean papers would have to be served as well as on the current licence holders, on the potential new licence holders as well. And this in itself may lead to problems in any sanctions imposed by yourselves. So I recognise this and certainly don't wish to be part of a scenario like that, i.e. where I'm causing confusion. Additionally, changing the licence holders partway through proceedings such as these may be viewed in some quarters as a cynical attempt to abrogate responsibility. Again, we wanted no part of that, and I sincerely hope that my submission to you today reflects the fact that the management in place accepts their part in why these proceedings have taken place, why they are taking place, and their solutions for it. That's why today I'm proposing a change of premises licence holder and DPS. And in order for that to be binding, you may well consider imposing a condition on the licence as a result of these proceedings today. Now, I'm aware that Section 182 guidance, which has been referred to quite extensively this afternoon, instructs you to seriously consider revoking the licence. Committee, there are strong words, and that is strong advice. However, it is not an outright instruction to revoke, and you are, in my humble opinion, entitled to consider the mitigating factors here. I've already outlined the circumstances about Mr. Wilk, who is the only person the management has been fined for in relation to immigration matters. I've already outlined the circumstances about the tried and tested steps taken by the management during the past 12 months to ensure that the licensing objectives are correctly promoted. A lack of evidence to the contrary displays the success of these steps, in my opinion. Committee, in conclusion, I submit that the passage of time in this matter, 4 days short of a year, has shown that those currently running the site can be trusted to uphold and promote the licensing objectives. And I further submit that in these uncertain times for the hospitality sector, the revocation of this licence will simply mean that the business closes and a number of people will instantly be unemployed. Indeed, even a suspension of the ability to supply alcohol will be devastating for the business. My clients tell me that their alcohol turnover is probably 45% of their business, rising another 10% during the summer months. Now, I realise that your deliberations have to go further than my last couple of statements, but contend that this site is not problematic to any responsible authority, and that those involved have learnt a salutary lesson from November 2024. I would reiterate that apart from the immigrations team report, nothing detrimental about the management or this premises has been produced for you to consider today. I submit that my clients can be given credit for the way they've dealt with it and their running of a successful and compliant business. Committee, Chair, thank you for your time this afternoon.
Thank you. Just get clarification. I think you said Mr. Mia is just a leaseholder. How long has he just been the leaseholder and not involved in the business?
Since 2019.
And it's because you've also mentioned the DPS change, which is also something normally they give us as we can look at. If he's not been part of the business since 2019, why has it not been changed or looked at before that?
From my instructions, Mr. Mia has been, he's been in contact with the owners of the business and has regular contact with them. But that is something that I must guard my words carefully here, Chair. I think it's something that, as I alluded to, there was a control issue. And I think if I could leave it at that.
Of course you can. No, that's fine. Members, any questions? No?
Yeah, in a way, I feel I want to go back to immigration to clarify something, but I'll go to first to you, Mr. Thornton. You mentioned, and looking through this report, which I'm glad you actually clarified Brian Will, because I had no idea who he was, but that now makes it clear. Now, you mentioned that he only came into the restaurant, quote me if I'm wrong, to avoid basically being stuck in a flat and watching UK TV. Fine reason in itself. But if he is the individual that's referred to on pages 26 to 29 of the pack that we have here, and I assume this is him because it mentions United States as his nationality, he states here that he does 4 to 8 hours a day, mainly on Fridays and Saturdays, but also weekdays if his cousin asks him for help. So on that basis, it doesn't seem to me it's a person who just came in one evening because he was bored sitting in a flat. I believe, is he also the person that's on a Works app group for employees? I'd ask why he's on a Works app group for employees if he's just a volunteer. And what's the other point I was going to mention here? It's a bit difficult, so I'm going to have to go through you, and I appreciate you've been briefed.
No, you're right, don't worry.
Sorry, as you asked the question, I am paying attention, I do apologise.
No,
I just trying to clarify the information on the Works app group.
Yeah, by all means, feel free to do that, because I appreciate having to go through you rather directly through your clients. And the issue, I mean, no, I'll leave that one for now. Okay, if you can come back to me on that. Do you want to clarify with your clients?
Certainly. Sorry, sir. Yeah, so to confirm, yes, he was on the Works WhatsApp group, purely because he was part of the he knew the other members of staff there, and it was almost like a social WhatsApp group for him whilst he was in this country. As for the rest of it, yes, his main hours, his main times that he did work for a couple of hours was on a Friday and Saturday, and I'm not sure that the immigration team have actually bottomed out how much he was supposed to be working for the rest of the week.
Okay, well, I can only go on the information that's in the pack. I mean, maybe we can get immigration to clarify. If you propose a point to them, they'll get a chance to answer your questions in a minute. And you, obviously, we looked at the immigration aspect here, whether it's 1 or 2 workers and such like. I appreciate there's a fine only for 1. But the other points that we touched on, you did your best basically to go through and address those. But if I can come back to the issue about alcohol sales, clearly you know full well the responsibilities endorsed for a DPS and a licence holder. Alcohol training obviously is an important one for the staff to adhere to. There is reference here that the Home Office team felt that there had been training given to the staff, but the staff were unable to give any detail of whether they'd signed any forms or such like. There were no logs held, and again, that's if you're looking at a responsible business, then yes, you'd expect that to be in there because it's part of the requirements that we ask for. So it is of concern they're not listed. I'm assuming you're able to tell us now and confirm that these are now in place. Can you double check that for me?
So, with the greatest respect, I don't need to double check that. I've seen them myself. They are some very, I would suggest, pretty comprehensive documents at the site. And so, yes, they are all actually in position. All it's fully documented. In fact, I don't think they could actually do any more with documentation.
And my last question for you, and again, sorry to harp on about the alcohol issue, but are you aware, or can you ask your clients what alcohol training they actually provide? Is there anything signed now by employees? Obviously, you've said this is a year down the line, so I'm assuming there may have been a turnover in staff during that year. They may have taken some new employees on. Have they adhered to this, and what do they do now? What do they sign? What training do they give them?
Yes, sir. And moving on from my my last answer, they do have training records. It's in the form of a very thick training record booklet. It does take account, as I mentioned, the number of employees there that, and certainly not all of those employees that I mentioned would be engaged in the sale of alcohol. Some are engaged in the kitchen and so don't actually engage. But those that are engaged in the sale of alcohol, I can only tell you this afternoon that I have actually seen all of those records and they are up to date.
Thank you. I just wanted to go back to the DPS because it's just a point I'm struggling on, and I'm hoping you might be able to give reassurance, or when you're summing up, changing the DPS to someone that was managing and working at a place when this was happening is a concern to me. It's normally a go-to when we're looking at a subcommittee, we don't feel this person's running it. This person clearly wasn't running it, so changing it to someone that was is a concern. So I'm just wanting to voice that out so that if there's anything you can kind of clarify what's going to change. I'm not really sure how it's going to change. I guess the licensing have been, but putting the DPS as someone that was under this and allowing illegal workers there is a concern still at the moment for me. So I'm hoping maybe when you sum up, there might be some more reassurance coming.
I can address that now if you like.
Please do, yeah.
Well, the situation is that yes, Mr. Diaz was managing the site at the time, the 2nd of November, when his friend Mr. Wilk was arrested, and yes, it's something that, as a manager at the site, what's changed in a year? Well, what's changed in a year with Mr. Diaz is that he's become a personal licence holder. Now, to do that, when he makes his application, there is a mechanism for the police to object. That never happened when he made his application, and so the way he's gone about his business in actually organising the documentation and organising his staff, and certainly shown to me that he has got his act together, I suppose is one way of putting it. And I would also say to you, Chair, and to your committee, that a year is a long time, and this premises has been it's been highlighted by an immigration visit a year ago. It hasn't come to notice of the responsible authorities, notably the licensing authority and the police during that time, nor has it been subject to an official inspection. So I would suggest to you that Mr. Diaz has shown himself within that year, and if we're in a position where we can say, well, okay, mistakes have been made. How do we recover from mistakes? And do we recover from mistakes? And what actions have we taken in recovering from mistakes? And I would suggest that Mr. Diaz has recovered in an exemplary manner. And for those reasons, I would suggest to you that he would be eminently suitable as a DPS. I don't think I can answer any more.
No, I appreciate that. Thank you. Members, any more questions for Mr. Fulton? Yeah.
It's just one from me here. Because during the interview, the guy actually admitted to working at the premises twice a week. And it's quite different from what you just said in your report. Because you said you only maybe sitting down there and maybe helping when needed, but he actually admitted to working at the premises twice a week. And then from the pre-employment checks, when they ask him, only answer is, I don't know. Did the employer check your right to work or immigration status before they offer you the job? I don't know. Does your employer know you are not allowed to work in the UK? I don't know. I will assume not, though. Does your boss know your immigration status? Yes, he knows. I'm a visitor. And as employer, we expected him to do the due diligence. Before you can employ anybody in United Kingdom, you need to check the right to work to make sure they can actually work in the UK. Even if they're your family, I think I'm concerned here because it's not even supposed to be there and even helping at all.
Okay, Councillor, yes, I can address that. And I think if you look at the circumstances and Mr. Diaz being the employer, no, he probably no. If you asked him, he would say, no, I didn't check. And I think due to the circumstances of the actual situation, I don't think he considered that actually letting him pick a waiter's pad up and get himself off one of the seats in the restaurant to go and help out when they were busy, I don't think he didn't consider that to be working. So I would entirely agree with you, and I would entirely agree the onus is on them. But I think due to the nature of the circumstances and the fact that it's his cousin over from the States and all the circumstances surrounding it, I would entirely agree with you. He clearly hasn't made that connection, wrongly as it turns out. But I would suggest to you that it is not done with any intent to deliberately flout the immigration laws.
Do you have any questions for Mr. Fulton?
Yes, I do, Chair. A couple of things that I would like to raise, following on from my colleague, or the panel's comment about the fact that this person who was a relative of Mr. Diaz and that he didn't think to check because he's a relative makes no odds. The man was here on a visa and it was a tourist visa. The restrictions of that tourist visa are no work, no recourse to public funds. Now, he would have been aware of that himself, having applied for that visa. He would have known he's not allowed to work. Anything that benefits a business, regardless of whether they are paid for their services in money, in food, in drink, in accommodation, whatever, it benefits the business. It's classed as employment. Any employer should ensure that anyone that crosses the business threshold has the correct permissions to work, regardless of any filial connection. I notice that a comment was made that immigration heard the accent of Mr. Wilk, and I would like to be quite robust in stating that because of Singh versus Hammond, we do not make any interview based on anything regarding accent or appearance. He was in a kitchen, there was 8 people encountered, we were a small team, it takes a while to get through the amount of people that we've encountered. So I would like the panel please to take into account that Mr. Wilk's accent had absolutely nothing to do with it. He was in the kitchen after he was arrested and searched. The waiter pad had come out of his pocket. He clearly stated he's been there on a regular basis. So within an immigration concept, we do have the proof there that Mr. Diaz, okay, he said, oh, well, I didn't know, but it's your job to know. If you're a license holder or a manager, it's your job to know, not least from safety, but also from the lawful aspect of running a business, protecting your employees, protecting the people who you serve. It is quite an important factor. It's not to be glossed over. The reason immigration were there were to find out people who have, whether they had the correct permissions to work, and we found that this gentleman did not. So that was one of the other things that I wanted to comment on. And he said that it was a shock that it's taken this long for a licence review to be triggered. These things do take time, especially when you take into account that they are allowed to appeal, and they did. But because they've not paid their penalty, this has then triggered this response and this process. So it really shouldn't come as a shock that if you fail to pay the civil penalty, that the Home Office will take further action. It just takes time like everything else. One other point I would also like to make is that Mr. Diaz said that he just wanted immigration out of there, which is why he didn't allow us access to CCTV. Had he done so, we may have been able to prove the people who were or were not working there lawfully. In this instance, it would probably clearly have shown Mr. Wilk taking orders, as he said, using his order pad, seating people at the seat, like he said in his interview, serving them drinks, like he said, which he's got no right to do because he is he has no right to work. So he is serving alcohol, which he has no right to do. So that prevented us from actually conducting our lawful duty. He stood in the way of immigration officers trying to make sure that they had everything covered. He could have helped himself had he granted us access to CCTV. One could possibly say that the reason we weren't granted access is because it would clearly show people working who shouldn't have been there, of which Mr. Wilk was one. So that is something else that I would like to bring to the panel's attention. He did actually say how many hours, because the point was made that immigration hadn't bottomed out how many hours he was working. It clearly shows in the entrance in our pack, in the entries, that yes, he stated he does 4 to 8 hours a day, mainly Fridays and Saturdays, but weekdays if he's asked. Thank you, panel.
Can I just follow up on something Mr. Thornton said about again, it was about the time frame. When you do searches like this, how quickly do you notify the licensing authority that you've carried this out?
It depends on whether we're granted a wash-up, because we don't just do one visit, we normally do 5 on a day. And if they're all under Section 179, then obviously we do it as soon as reasonably practicable, and it is one of the first things that an OIC will do, because obviously it will set in train a procedure. So it's normally within 24 hours to 48. To make sure that we can get all of that started. Also, bear in mind, if there's 8 people, so for instance, if I was OIC for this job, I would have gone back to the office. We would then have to go through all the forms, collate all the evidence, and then notify our civil penalties team that we've served a civil penalty referral notice, go through all of the illegal working interviews that were conducted, and then the CPCT team then have the opportunity to contact the business. That's a separate entity to me. I can just give them the information. but we set that in train as soon as reasonably practicable.
Thank you. Do you have any
You're
questions?
welcome.
Yes, do. No, couple of questions. I would like to know when Mr. Diaz actually obtained his personal licence, so that we can get a timeline, and who's actually completed the training, and when this training was actually completed in this last year.
Thank you, Chair. So if I understand the question correctly, is when did Mr. Diaz obtain his personal alcohol licence? And could you just clarify the second part of the question? Sorry.
Obviously, you've stated that now all staff have been trained. I would like to know rough dates of when the staff training was completed, i.e. was it just after this incident when they realised that they hadn't got a training log, or was it in the last time since Mr. Diaz has obtained his personal licence?
Right, okay. I think I understand it. Mr. Diaz obtained his personal alcohol licence beginning of April, having conducted his, having done his test through the training provider in sometime in January, as I understand. And then the delay beyond that is paperwork, etc., and getting the actual licence issued. And as for training, off the top of my head and off the top of his head, I can't tell you exact dates for the training, but the training has been conducted certainly since Mr. Diaz has taken over, so it's not a knee-jerk, oh, let's do it on the 3rd of November. If that's what's being alluded to, it has been conducted recently.
I'd also like to know if Mr. Maya has had any further involvement in the business in the last year.
Well, other than the circumstances that I alluded to earlier on, where Mr. Mia has been, I hesitate to use the word sleeping partner, but almost as a sleeping partner in the whole thing. Mr. Diaz has been running the business since then, so Mr. Mia has not really had any interjection into the business and into the way it's been running.
So just to clarify, the DPS has had no involvement in the business in the last year?
I think that would be a fair assumption insofar as, other than keeping in contact with them, but actually for running the business and doing training, etc., no.
I've got date 2019 on mine from when I asked earlier. Just to, yeah, I know. That's what, to get the timeline. Yeah, yeah, go for it.
What I was thinking about, because I know the way this the restaurant work in that place is pre-booked. You must have known the customer coming. I think they always book. It's not just like customer is just turning up, they already booked. Because you said that the guy is just coming to help, maybe when they have more customers. But the way that customer is, I think the way they do things or the way they serve their customers, they already booked. So they know the number of customers each day. So they must have had the normal or the number of staff working. So because I don't really understand, if you can just expatiate more on that. Do they pre-book the customers or the customer just come in?
Thank you, Chair. Right. You may well have seen by some of the shaking of the head and hearing some of the conversation there. There's a significant proportion of walk-up, and it's not all bookings. During the summer months, and this November clearly wasn't during the summer months, during the summer months, booking is advisable, but it's not all bookings, so it's, there is a substantial number of walk-ups.
Anyone got any more questions? Derek, do you have any questions for Ms Thornton?
No, thank you.
Chair, I just have one question of the immigration officer. I appreciate that's out of turn, but there appears to be a difference of opinion as to the number of unlawful workers at the premises at the time of the raid at the premises. Your position is very clear that there were 2 unlawful workers, but we've heard from Mr Thornton that there was in fact only 1. So I was wondering if you could address that, and also precisely why only 1 of the 2, as a follow-up point, was the subject of the penalty.
Yeah, I believe I've already covered that. So 2 people were identified as having no right to work. But unfortunately, they were both put on the civil penalty referral notice. We then referred that to our civil penalties team. The civil penalties team then interview the business, and then they decide whether each worker reaches the threshold to continue to be added to the civil penalty referral notice. They have apparently had access to that information and decided that Mr Brian Wilk was the person who could, they had enough information on that reached the threshold for the issuing of a civil penalty in respect of that person. The second person did not quite reach that threshold. I am not privy to that information because I don't work for the civil penalties team, nor am I involved in the decision-making process. I did ask them what that was or what the reason was, and they said we can't really give that information, but all we can tell you is that one of these people failed to reach the threshold.
And you're not able to give any more detail as to the reasons for that?
Not to me, they didn't know.
I think you have just covered this, but I'm guessing you don't know what the threshold is for it.
I don't know because I'm an immigration officer. I'm not, with all due respect, I'm not a civil penalties officer. But no, they didn't tell me that information.
No problem. Any more questions from anyone?
Well, yeah, because I want to clarify. This is somewhat confusing. I appreciate you not being told by one of your colleagues in a different department what the reasons were why they didn't. Is this a separate department for you? It's part of the immigration office, is it? The civil penalty office with the team, whatever it is, that give the penalties. That's part of your organisation, is that correct?
It's part of the organisation, but we are just an arrest team. We go out, assimilate information, and then hand it over to someone else. It's
So
not that I'm part of that.
Why won't they tell you since they're one of your colleagues?
I
Isn't it
don't know.
vague?
I can't answer
Okay.
that question at the moment.
So, to be fair to Mr Thornton then, there is a point, it would seem to me now what's been said, that actually it was only 1 illegal worker, not 2. Because if we can't put grounds to actually fine an employer, that would basically seem to me that that was not an illegal worker.
Right, so we arrest on suspicion and we try and investigate as to the grounds. So that's precisely what we did. But they have seen fit to say that only 1 of them reaches the threshold to be the part of the civil penalty. It doesn't mean to say they weren't working illegally. It just means they can't be added to the civil penalty referral notice because the threshold to enable that for him to be added was not met.
Okay, right. I'm going to move on to summing up now. I will go to... we're putting you on the spot today. Sorry. Wait, Derek, have you got anything else to add? No?
No, nothing.
Fine, I didn't think you would. Perfect. Back to you to sum up. I'm sorry. It's very rare we have an immigration officer here, so we've got lots of questions. So, summing up to you first.
So yes, in my summing up, I shall be brief. The Home Office does not wish to be involved in any unnecessarily restricting genuine community services such as successful pubs, restaurants or shops. However, there are serious concerns over the way this business was being run, as earlier discussed. There needs to be some remedy to that behaviour and a significant way of ensuring that this will not be repeated. This should also serve as a clear message to other businesses who are fully compliant with relevant legislation that satisfactory action has been taken. We have outlined our position that those in charge at Casa Flamenca are ultimately responsible for the illegal working at the premises, and we've shown through our thorough evidence from this visit in November 2024 that illegal working was occurring at this premises. We have no confidence in the licence holder upholding the licensing objectives going forward. We've therefore presented the evidence to inform the committee's considerations and to draw its attention to the significant risk of the prevention and crime and disorder objective being undermined. In line with the guidance, the Home Office is therefore seeking the subcommittee to consider revoking the premises licence. Thank you.
Thank you. And then I'll call to you to sum up.
Thank you. Very short and sweet from ourselves. It's just that the concerns are that there's been no DPS involvement for almost over 6 years. And again, it's taken almost 6 months to get somebody to get their licence, to then do training after this instance. The male was clearly working at the premises with the evidence that's been provided, and this was by the manager's own admission that it was their family, so they were being fully aware that this visa would have been in place, that they would only been on visitor's visas. Again, we stand by the immigration and that revocation is the only outcome on this licence.
Thank you. And lastly, Mr. Thornton, please.
I probably said all that I need to say regarding the actions of the staff and management at this site since during the last year, since the visit. I do note the opprobrium regarding the DPS. That may well have been addressed with a visit by one of the responsible authorities, which is always open to them, especially when there's review proceedings having taken place. So I'm not sure that the current management should be criticised for that. And I just wish to reiterate that although, yes, 2 people were arrested at the site, subsequent investigation has deemed that only 1 worker was actually working illegally, and that was Mr. Wilk and not Mr. Ruano. Can I just, one quick thing, Chair, and at the risk of causing, I didn't wish to cause any angst to the lady from the immigration. My comment about when they heard an American accent was probably, the greatest respect has probably been taken slightly out of context. It wasn't meant as a slight that the immigration were targeting someone just because of their accent. So if I can just get that in, that was meant in an entirely different way. I genuinely do not mean any offence there, and if it's been taken, then I apologise. Thank you, Chair, for your time.
Thank you. Just want to confirm, is everyone satisfied and said everything they wanted to? Okay. So we're going to move into closed session. What's the time? 4?
3:15, 3:16, 4 o'clock.
I think 45 minutes is probably a reasonable period of time for you to consider everything, make your decision, formulate your reasons. I know this is out of turn, Chair, but I do generally prefer to give legal advice in open session rather than when you've retired. I know that during the course of the proceedings it has been mentioned that you might consider a condition requiring the transfer of the premises licence and the appointment of a new DPS. My advice is that those are separate processes to the review process, and that you ought not to consider imposing a condition requiring those. As I say, it's a separate process and it's subject to objection, and it may have real difficulty with enforcement, and for those reasons I would advise against such a condition. That's the only legal advice that I can think of at this stage that I would offer you when you go into closed session, so I make it now an open session so everybody's aware. I don't know if there are any comments arising from that. No, shake of heads. So we're clear to go into closed session. I think 45 minutes at least. What that means is that the subcommittee will not reconvene before 4 o'clock, irrespective of whether it makes its decision and formulates its reasons before then. It may take longer, but it will not reconvene before then, so you can go away, have a cup of coffee, stretch your legs, safe in the knowledge that nothing will happen until 4 o'clock at the earliest. If whilst you're perambulating around the building, you do happen to bump into any of the members, please don't engage in any conversation. That makes a very difficult situation. They've been instructed not to engage in conversation, and they will ignore you for that reason. Thank you, Chair.
Can I just say something really quickly? I'd just like to say thank you ever so much for what you said. Bearing in mind my job, things like that, we are governed by Singh versus Hammond, and I just wanted to make it clear that we don't actually do that. But thank you for taking the time to say that and to apologise. I wasn't offended in the slightest, but thank you, sir.